State, federal, and international privacy laws are wrecking the space for businesses who want to do marketing. Hi, I'm Justin Hitt with Ad Briefing's Copywriting Tips. As a copywriter, marketer, or business development professional, you need to be aware about the do not call, do not email, do not fax, and variety of privacy laws associated with the list data that you have for your customers. Now, this is a very complex topic that I'm going to try to cover briefly in this podcast. The key to understanding here is that the information you gather about and from your customers is restricted data. I know everybody puts the "we will not sell or trade or spam you with the information." You know, customers are very weary about opting in. It's very important to understand that it's not just a disclosure. It's not just saying that you can unsubscribe anytime. And for information about privacy practices, visit this page. There are law firms that have created a whole industry out of the threat letter. I don't know if you've ever received them, but it's the fax letter that you receive or the email that you receive or the telephone call that you receive that basically says you have violated the privacy of my client, and we're asking you to pay $500 or we're going to sue you in court. And that's just kind of a high level of the letter. I've received these letters a number of times. Anybody who is regularly sending marketing campaigns is going to receive one of these letters periodically. And that's because lawyers gather lists and they rent lists and they buy lists of cross-state marketers to basically send it's a threat letter to get their $500, because the law, the way they're written, is that you can get fined up to $10,000 per transaction. When canned spam first came out, there were people getting hit for hundreds of thousands of dollars. Little tiny marketers who don't send out a lot of copy, who try their best to keep their list clean, and they were getting nailed with fines because their recipient, and sometimes it's not even their recipient, but their recipient decided they didn't want to get that message anymore, and they flagged it as spam. They didn't just flag it with spam. They actually contacted their lawyer and tried to extort from you money for marketing. Now, how do we handle this? So as a marketer or copywriter, a copywriter can sometimes stay out of the problem because they just wrote the copy. I only wrote the copy. The legal that you'll have to worry about as the copywriter is the truthfulness of the piece, the proving of claims, those items. But again, though, if someone sends your copy to a list of people who said they did not want to receive emails, it might be easier to trace you back than it would be the company sending it, depending on who's doing what. There are situations where a copy might get reused. So you wrote an email campaign or a web campaign, and it gets reused as a fax broadcast. Now, not many people are doing fax broadcasts anymore, but if you're in the business-to-business world and you've got a direct fax line, it's just like sending email. The difference is there are a bunch of fax-related laws where you have to have an existing business relationship. It's called an EBR, an existing business relationship. So what about a marketer? Well, you're working with a client and you're helping them acquire their lists, and those lists aren't clean. Now, a reputable list management company will scrub the list. They're going to scrub that list, and they're going to make sure it's been ran up against the national do not call list. They're going to make sure that it's been ran up against state and sometimes international do not call list. Did you know somebody could have a Gmail account but be located in the European Union, and then the GDPR, which is the I don't know, I always think it means Global Declaration Against Marketing, but the GDPR, which is a privacy general data protection regulation from the EU, could be a factor in your website, in the emails that you're sending out, in the text messages that you're sending out, in the postal mail that you're sending out. Now, when you're sending postal mail, you can know it's an EU address and you can scrub those. But what do we do as marketers? What do we do as business development professionals? How do we prevent the very expensive cost of making mistakes with our mailing lists? It is almost like governments don't want you to market. They don't want you to unlock the potential that's there of making an offer to people who are interested. And perhaps maybe the government doesn't understand that as a marketer, you're not going to send messages to people who haven't pre-qualified, because it's just a waste of your time. You're going to do a bunch of printing and send it to people who haven't showed any interest, then it's kind of a waste of time. Unfortunately, though, there are also businesses out there who willy-nilly just send marketing to anybody. They get a software program, or they buy one of those CDs full of email addresses, and they take your copy and send it to a broad group of people, and it causes problems. It causes real problems. Now, yes, you can arm's length it. So another way that you stay out of trouble is you arm's length it. You explain in your contract that you're just providing the copy. You're just providing the marketing strategy. You're not responsible for list acquisition. You're not responsible for how they use the copy. You have a mutually exclusive arrangement where they can use it and you can use it. And then that way you've got some coverage where you can define your usage and they define their usage. And then if there's a problem, you can see, on whose usage was the problem. There's a lot of factors there, but here's the biggest thing. Who you choose as a client is very important. Yeah, I'm sure you'd love to be doing business with the big reputable organizations, the Agoras, the big publishing companies, Reader's Digest, Publisher Clearinghouse, large marketers, large national names, but that might not always be possible. But you can do due diligence with your client as part of your initial or paid consultation to just find out how do they handle their national do not call. Now, the way national do not call works in the United States is that there will be one list of every customer who's been scrubbed up against the national do not call. So if you send the list away to a service bureau, they'll flag the names that you have to delete from your list or you have to omit from your list. Or you may maintain in-house a national do not call and actually hire a service that will update your local list. You'll definitely need to have a single do not contact list. So the national do not call list has to do with phone numbers. The do not contact list is anybody who has ever asked your company not to contact them again. Did you know that if someone solicits you and you say, hey, put me on your do not call list, and they call you again, or put me on your do not contact list and they contact you again, that you have the rights to like $1,500? And there's an extortion letter you can buy in a kit to send to every company who solicits you, who does not explicitly have your permission to be soliciting you. Now, you and I know that there's lots of things that consumers want to buy, that businesses want to buy, that they do not know exist. They have problems and they don't know what solution, so they don't know how to go ask for that solution, and therefore they can't get on your list in the first place. And that's why we go to the list rental market to find people who have asked for similar information and then help them with the opportunity to find the solution that they're looking for. But if they ever call you and they tell you, hey, don't contact me, you need to scrub that list. Now, in my case, I actually have email addresses that are I've been doing this for nearly 20 years. I've got email addresses on my single do not contact or do not email list. They're 20 years old. It's not likely those email addresses are any good anymore. It's possible, but I still scrub against those because if that person ever opts in again, they need to come off the do not contact list because they've again given me permission. I need to maintain a record of their opt-in. See, a lot of you folks are saying, well, I want to migrate from Infusionsoft to Aweber, and Aweber won't let me load my lists. Well, guess what? They would also be liable if they sent the email. So they're working as an agent to you, and they sent the email, and there were emails on there that had a do not contact. It would be a problem. Now, some business development folks will actually manage the whole marketing campaign for the client. So I've hired out marketing coordinators periodically that they literally manage the day-to-day activities of the marketing campaign. And in that type of contract, I actually do take on liability because if my person scrubs a list with a service bureau, for example, and then they download it and they got a clean list and they've got the original list, and they accidentally send the mailing to the original list rather than the clean list, then I've got liability on that because my contractor made a mistake. So me as a contractor to my client has made a mistake, therefore I would be liable for that. And then you would want to have certain types of insurance in place. So there's errors in omissions insurance, and there's also other types of liability insurance that cover these types of things that can happen. Now, I know as a copywriter, a marketer, a business development person, you want to get out there and sell. You want to get out there and market. You want to be creative. But the truth of the matter is with state, federal, and internationally binding laws, being on the internet can be a huge problem. Sometimes sending certain types of social media messages can be a huge problem. But ultimately, to hedge that risk, there's insurance, there's contracts, and there's how you approach the work. Now, again, you might say, well, Justin, I'm just going to write copy. I'm going to hand it to the client. I'm going to get a waiver of liability. We'll have the mutually exclusive agreement so I can recycle the copy, but ultimately, their copy, their problem. Well, unfortunately, that limits you into the service areas for ongoing revenue. So, for example, you write 100 pay-per-click ads for 5 products. You might be saying, God, Justin, if I just had that job, I would be incredible, because most of the time I'm writing 2 pay-per-click ads to A/B split on one product, and then the customer never comes back. Well, to get from single one-off job in order to multiple reoccurring business with a single client, you've got to be able to do more than just write copy. See, the guys on Fiverr can write copy. You know, you can get a guy off of one of these AWAI programs, recent graduate. You can get them to write copy. But again, if you want the dollars, the 5-figure contracts, the $10,000 starting fees, you need to have the strategy part. You need to have some of the services. You need to have maybe help with list selection. So you want to do 2 things. First off, you want to be aware of the laws, like the General Data Protection Regulation, the GDPR. You want to be aware, for example, that California just released a new privacy law that basically is worse than the one they had before. There's a lot of different states that have privacy laws. You need to be aware of these things. You need to be aware that there's if you're doing a health-related offer, there's the Health Insurance Portability and Accountability Act, HIPAA. And you might be saying, well, Justin, what does that have to do with marketing? Well, once you get a list of people with diabetes, so you send out a lead generation, they raise their hand and say, yes, I've got diabetes and I'm concerned about diabetes and I want more information. Now you have a list that requires medical control, not just all these privacy controls. Now, what if you're marketing an area like video games? You're writing copy for a video game company. Did you know that as they generate leads, they need to be aware of the Children's Online Privacy Protection Act, COPPA? It really gets messy. However, it's messy enough that your client is not going to be able to do this. So the second part of the plan is to basically educate your client. Educate them about the downfalls. Hey, you could just hire somebody online. You could just get a CD with a bunch of emails on it. You could just audience match. This is where there's got to be some challenges. You could audience match on Facebook and end up reaching people who don't want to be reached by you, which puts up the liability. Now, of course, the bigger solution, and we can talk about this in another program, is to make sure you got double opt-in in place. And see, here's where you go from writing copy to being a service provider, because you're probably going to have a webmaster anyway. Get a webmaster who understands the double opt-in mechanisms for a couple different platforms. Offer that out to your clients to make sure the clients are getting and can sustain evidence of permission to market. So I had an issue a while back where I'm maintaining my do not call list. I'm maintaining my do not contact, do not email, do not fax. And I've got these files. They're Excel spreadsheets. And so when I go to rent a list from somebody, I give the list broker my do not contact list. And they will scrub it so they can give me only people I have permission to reach out to off of the rented list. I still get this stupid letter in the mail, basically extorting $1,500. They basically, the way the letter goes is, hey, you've reached out to my client who's explicitly asked your organization not to contact them. And if you'd like this to go away, send us $500. Otherwise, we're going to sue you for $1,500. And I don't have that. I don't know if I still have that letter. I might have put that in a kit somewhere. But ultimately, I was a little scared because I'd rented this list. I gave them my do not contacts. The situation came up where I contacted the lawyer and I said, look, you're going to have to give me a list of all the phone numbers, the email addresses, the postal addresses, every piece of relevant information so that I can go on my list and give you the evidence that that person opted in, because I had a pretty good opt-in mechanism. And ultimately, they, after going back and forth a little bit, which is a huge pain in the ass, they gave me a couple email addresses, and it turns out that I didn't actually have the original email address that was on the do not contact. I had a aliased email address. It had similar names and stuff. The first and last name matched. And this person had basically opted back into my list. So I was able to give them a screenshot of when this alias opted in and explain to them that I have no idea that this forwards to this other email address and that we go on an email by email basis. But here's what I can offer you. I could put the new email address on my do not contact. And we got out of it. But ultimately, again, if I didn't have the right education to know what these privacy laws are, I might have been a little more concerned about the extortion letter. If my client, in the case I was doing my own client, but ultimately if I didn't have the opt-in mechanisms in place and the records in place, I could have been screwed pretty bad. If you've got questions about this or anything else that we talk about, do remember that a privacy violation under any of these rules can be $100 per instance to $10,000 per instance. And for some of the do not call, you could be looking at $20,000 per instance. It's a very serious thing. So if you've got any questions about the privacy law, I can put you in touch with a lawyer. I can put you in touch with folks who are working on the marketer side, especially if you're in Maryland, New York, Hawaii, Massachusetts, California, North Dakota. All these places have new U.S. state data privacy laws. I can answer questions for you about how to handle the data and where to manage the data. Many of the tools that are available today do an inadequate job, to say the least. But most importantly, if you have any questions about marketing and privacy rights from a marketer's perspective, visit www.adbriefings.co.uk and ask your questions. I'm Justin Hitt with Ad Briefings Copywriting Tips, here to deliver to you more than words that sell, but how to run the business of copywriting. If you want to build an agency or you want to be a 6-figure, 7-figure copywriter, you're in the right place. Thanks for listening.